individuals charged with crimes that they deemed unjust, such as violations of the Stamp Act. This resistance to oppressive laws ultimately contributed to the American Revolution. The right to a trial by jury and the potential for jury nullification found a place in the U.S. Constitution with the 6th and 7th Amendments guaranteeing the right to a jury trial in criminal and civil cases. As a result, jury nullification became a powerful check on government authority, allowing jurors to act as a safeguard against unjust laws and prosecutions. While the
That's a very, very, very important point, what he just said. Your legislators are constantly, your mayors are constantly, making ordinances, making laws. And then you go to court, and even though it's unconstitutional, you take it up to the Supreme Court. But you could stop this by being in a jury. It's your duty to be on a juror. It's your duty to look at the laws to see if they are just or not just. We are the final check of balance of our government. All right, let's continue on. I just want to bring that point up.
The historical context of jury nullification is well established. Its relevance in modern legal systems may be less apparent. However, jury nullification continues to play a significant role in the criminal justice process for several reasons. Jurors may still hold strong moral or ethical objections to certain laws or prosecutions, leading them to nullify verdicts that they find unjust. For example, in cases involving nonviolent drug offenses, some jurors may believe that the crime doesn't warrant prosecution to send a message to the prosecution. Jurors may sympathize with the defendant's circumstances, such as cases involving desperate individuals driven to commit crimes due to economic hardship or personal struggles. High-profile cases and social movements can influence jurors' perceptions and decisions. Jurors may be more likely to nullify verdicts when they believe that the broader public sentiment supports their actions. In some cases, prosecutors may overcharge defendants or pursue charges that appear to be politically motivated. Jurors may use nullification as a means to curb prosecutorial overreach. In fact, with the upcoming prosecution of former President Trump, there is a lot of public hand-wringing over the possibility that Trump may be acquitted as a result of jury nullification, even if the government proves guilt beyond a reasonable doubt. Only time will tell. The use of jury nullification has led to legal debates and challenges. On one hand, some legal scholars argue that jury nullification is a fundamental right and an essential component of a democratic society. They contend that it allows jurors to act as a check on government power when laws are unjust or enforcement is excessive.
There you go.
The legal landscape regarding jury nullification varies by jurisdiction. Some states have explicitly recognized the right of jurors to nullify verdicts, while others have taken measures to limit or discourage its use. For example, some states, such as New Hampshire, have passed legislation explicitly acknowledging a juror's right to nullify and ensuring that judges inform juries of this right during trials. In contrast, other states require judges to provide limited instructions to jurors about their duty to apply the law as written, discouraging nullification. The courts in these states have determined that a defendant does
discouraging. He used the word discouraging in that. That doesn't mean that you can't go on with that. Just making a point there.
Not have a constitutional right to give the jury an instructions about nullification or to explicitly argue in favor of nullification. Prosecutors may use their discretion to decide whether to pursue charges when they anticipate the outcome of a case will be influenced by potential nullification. Some recent and historical cases illustrate the role of jury nullification in American courts. In 1850, the U.S. passed the Fugitive Slave Act, which required the return of escaped slaves. Juries in northern states would frequently engage in jury nullification to acquit those charged with harboring slaves. In the midst of the war on drugs, there have been instances where juries acquitted defendants charged with minor drug offenses despite overwhelming evidence of guilt. Jurors in these cases may have been motivated by their belief that the laws were overly harsh or unjust. Dr. Kevorkian was a proponent of assisted unaliving for people who suffered from terminal and debilitating illnesses. Juries acquitted him in 3 separate trials after hearing evidence related to the suffering that the victims in the case had endured and how Dr. Kevorkian sought to relieve that pain. Because most courts have taken a very strict approach when it comes to even discussing jury nullification, it is likely that many jurors who vote to acquit are already actively engaged in nullification but refuse to admit it for fear of retribution. The use of jury nullification raises complex ethical dilemmas. While some view it as a form of civil disobedience and a safeguard against injustice, others argue that it can undermine the rule of law and erode respect for the judicial system. Controversies surrounding jury nullification include inconsistent verdicts. Critics argue that jury nullification can lead to inconsistent verdicts, making it difficult to predict case outcomes and potentially resulting in unequal justice. Potential for abuse. There is concern that jury nullification could be abused in cases involving powerful defendants, like celebrities or politicians. This would allow jurors to ignore clear evidence of guilt, even in cases involving heinous crimes. Compromise of legal system. Some argue that nullification compromises the legal system's integrity, as jurors are sworn to apply the law and not engage in personal or moral judgments. Opponents of jury nullification contend that juries should apply the law as written, leaving questions of legality to the courts and legislatures rather than in the hands of citizens.
I would like to stop that right there. That's where I would like to see the line drawn. Leaving it up to the courts and the legislators rather than the hands of the citizens. Can you believe what they just said there? But that's what's going on, folks. They're leaving it up to the legislators. Now, in my personal opinion, I'm going to give you my personal, I think the legislators should go ahead and make up the laws. But we as the American people should have the right to vote on a law. Every law that is made, I believe we should have a say in it. We should have a vote in it. And whatever the majority is, what that vote should be. But we are not allowed to do that. And the only way we can do it is by jury nullification. I just want to bring that point up.
In recent years, jury nullification has gained renewed attention in high-profile cases, such as those involving activists and whistleblowers. In 2010, Julian Heiplin was criminally prosecuted for jury tampering after distributing pamphlets outside of a federal courthouse on multiple occasions. The pamphlets informed people about jury nullification and told potential jurors that it just takes one strong-minded juror to hang the jury. A hung jury occurs when they are unable to reach a verdict and results in a mistrial. Mr. Heiplin's criminal charges were later dismissed on First Amendment grounds. In 2015, former pastor Keith Wood was handing out jury nullification pamphlets outside of a courthouse prior to the commencement of jury selection. The people he handed pamphlets to were summoned for jury duty, but had not yet been selected for service. Mr. Wood was convicted of jury tampering, ironically, by a jury. In 2020, the Michigan Supreme Court overturned the conviction after finding that the people summoned for jury duty, but not yet selected for service, were not jurors under the definition in the law as to who could be tampered with. The court
basically they he overturned that, and he was able to set it free. Anyway, a lot of judges. I've only had one judge in my lifetime tell me about jury nullification, but most judges, they don't want you to know this. They don't want you to know this because we are the balance and checks of our government. Just like right now, we have a majority of the Senate of one side and representatives, House of Representatives on the other side. And basically, they could deadlock everything and nothing would be done for 3 years. But here's where the check and balance comes in. You know, we, the people, will have the vote and break that deadlock. We, the people, have the right to jury nullification. Anyway, folks, I thought this was kind of interesting food for thought to bring up. And spread the word, let people know about jury nullification, because I think every juror should know that, and they don't teach that. And I think everybody should know it. So spread the word on this. Please like, subscribe, add any comments in the comment section of this video, and I'll try to answer them. And again, please subscribe. It helps my channel grow. Hit the like button. If you want notifications, hit that bell. Anytime I upload something or go live stream, it'll give you a notification. Anyway, if you want to see the rest of this video, you can go to my description and click on that link, and it'll take you to Keith Wood here, or to the guy that made this video here. Anyway, just wanted to point out, you guys have a great day, and I'll catch you on the next one, and God bless you all. Take care. Bye now.